I'm Janet Brewer, a California estate planning attorney. Once in a while, it's helpful to review the basics. Most people are aware of trusts. Some of you may be named in a trust, for example, as a beneficiary. You may be the trustee of a friend's trust, or you even may be planning to create a trust of your own. Let's take a few minutes to go over the basic definitions and functions of a trust. It may help you if one day you are asked to be a trustee, or as you dive into your own estate planning. What is a trust? A trust, simply stated, is a legal relationship in which one party, the trustee, holds property for the benefit of another party, the beneficiary. Think of a trust like a bucket. A person puts something into the bucket, such as real estate, art, or other assets. That person is called a grantor or a trust maker. Another person or a designated institution may manage what's in the bucket after the grantor passes away or becomes incapacitated. That person or institution is called the trustee. It's that person's job to make sure that everything is accounted for and gets taken out of the bucket according to the grantor's wishes. The third person in this legal relationship is known as the beneficiary. This envied person's role is to receive some benefit from what was placed in the bucket. What might prove tricky in this three-way legal relationship is that one person can have more than one role at the same time, and similarly, more than one person can play the same role at the same time. One person can even play all three roles. This is most often found in a living trust, which is a trust created for the trust maker and managed by the trustee while the trust maker is still alive. For example, a married couple can be the trust makers and the trustees and even be the beneficiaries at the same time. Now that you know what a trust is and how different people or organizations can play a role in it, it's time to dig a little deeper and discuss different types of trusts. Knowing the differences between these common trusts can help one choose the best trust for his or her estate. The first major difference is between living trusts and testamentary trusts. A living trust can be revocable or irrevocable. Revocable trusts can be altered by the trust maker. That is, they can be revoked while the trust maker is still alive and of sound mind. Alternatively, an irrevocable trust cannot be undone, and it stays the same as when it was established. Both revocable trusts and irrevocable trusts can be living trusts. That is, a trust created and operative while the person who created it, the grantor or the trust maker, is alive. A trust established after the death of a trust maker and based on his or her last will and testament is called a testamentary trust, in contrast with a living trust. You may hear trusts described as being simple or complex. This is a term that's used primarily for accounting purposes. A simple trust means that there are mandated payments of the trust income to the beneficiaries and that all of the income is paid out to the beneficiaries at least once a year. Complex trusts do not carry that same mandate. That is, they can accumulate income in the trust without having any required payouts. You may also hear about grantor trusts. This is a term that's used for tax purposes and deals with who is responsible for paying the taxes on any income that the assets in the trust might earn. In simplest terms, if a trust is not a grantor trust, then the trust itself is considered a separate taxpayer and must file its own separate tax return each year. So what do most people choose? Revocable living trusts are part of a basic estate plan. They're established during the grantor's lifetime and they can be altered according to the grantor's wishes. Irrevocable trusts are used most often in more complex estate planning, usually to save gift or estate taxes in large estates or to provide for young children or incapacitated adults, for example, special needs beneficiaries. In conclusion, it's always best to talk to a lawyer who specializes in trusts before deciding which type of trust is best for you. This refresher, however, will help you understand your options and prepare you for an efficient conversation with your lawyer. I'm Janet Brewer. If you need help planning your estate or establishing or updating a trust, please contact me at 650-325-8276 or visit my website at www.calprobate.com. That's www.calprobate.com. Thank you.